So it looks like we have Mr. Christensen on the screen. Let's everyone turn on their videos at least and see if we can make this work. And do either of you have any questions before we get started? Okay. And I didn't ask you to state your names for the record, but maybe when you begin your arguments, just please identify yourself so we make sure we have that clear on the record. All right, let's go ahead and begin. Mr. Fitzgerald, if you'll just turn your camera off and we'll see if we can make this work. Thank you. Oh, Mr. Christensen, I think you're muted.
Okay, I'll get this right. Your Honors, I am Steve Christensen representing Mr. Fischer in this appeal. We have presented our primary issue as challenging the unequal or inequitable distribution of assets in this divorce action. The court at the trial indicates on the record at page 777 an intention to make an equal division of the assets and suggests that the math would create a wash. And yet our calculation presented in our brief shows at least a disparity of $148,000 in favor of Ms. Fischer. The court, on its final draft of the findings, inserts a concern that there is maybe some unaddressed equity in the marital assets that would create an equitable division if considered, and cites to the business and cites to the house. The valuation of the business was not provided to the court, and the court made significant findings on record 364 and 365, indicating that the business was a pass-through entity, that it had no value, and that all its profits were distributed as income to Mr. Fischer. So that should not be a consideration for an disproportionate allocation of assets. The other concern the court raises is that there may be some kind of closing costs involved in the house. But there are two problems with that. First of all, there's no evidence of closing costs before the court. And second of all, there are other alternatives, namely those noted in the Bradford decision, where the court could have created an equitable allocation of the house. So we appeal the court's award of the marital home to Ms. Fischer, especially given that there's no commensurate offset from other assets to make that an equitable award.
What do you make of Mr. Fitzgerald's argument in the brief that your client was going around claiming that the business was worth as much as $2 million and did have some value?
We did address that in our reply brief, Your Honor, that $2 million had to do with the value of the clients that he represented, not the business that he had. His business is just an LLC. It just receives payments from his client and distributes those to him as income. And the court made findings very clearly along those lines. The business is, as the court said, similar to an attorney or an accountant. It just receives income that can be generated based on the abilities and the character, the personality of that specific person. And there's no, as a sole proprietor, there's no other inherent value in the business. It doesn't have any assets. The court didn't find any assets. So that valuation is not evidence. This is a situation very similar to Bradford. In Bradford, there was a home that was awarded to the wife. In this case, the same thing happened. But in this case, the only finding in support of awarding the home to the wife was that if it was not awarded to the wife, she would have no home. But the court can should consider other things, as the court suggested in Bradford. In Bradford, one thing the court suggested was, citing to the Cox versus Cox decision, that the ability of the spouses or the parties to support themselves could be a consideration. This is an asset-rich divorce. We had hundreds of thousands of dollars of cash assets. There's no reason why the court could not do a traditional split of the equity of the home. The court could have ordered it to be sold, and the concern of closing costs would have been taken care of in that process, with the costs netted proportionally to both sides, so there would be an equal division. Or, as suggested in the Bradford case, the court could have had the house appraised and had Ms. Fischer, if she wanted to buy the house, buy out the interest of Mr. Fischer. Two very doable alternatives in this case, where the parties had high income and high asset value. So we're asking the court to reverse the award of the house to Ms. Fischer and remand for the court to handle that asset in a more equitable way. The other, yes.
Mr.
Judge.
Christensen, wouldn't it worked? I think the court makes quite adequate findings about the propriety of awarding the home to her. I'm not sure that it's obviously a reversal of that that's called for, but the disparity in allocations does cry out, I think, or at least arguably, for further explanation by the trial court, because on its surface, it's a rather significant disparity. And while it might be appropriate to take judicial notice of some costs of sale and so forth that would cut into equity, those would be rather substantial closing costs and real estate commissions to eat up the amount of equity in issue. So taking the trial court at its word that awarding the house to her makes sense, isn't it perhaps more appropriate to simply remand for the making of further findings as to what warrants the disparity? Because it's really, in my humble opinion, and I'll be asking Mr. Fitzgerald about this, although maybe he'll just open with this, mindful of my concern. It's a big enough disparity as to cry out for some explanation beyond, well, under all the circumstances, or in view of the business, or given the possible costs of sale. That's a little loosey-goosey for what we usually expect in terms of detailed findings explaining a disparity. So what would you think about that by way of a remedy, namely a remand to explain the disparity? If the disparity cannot be otherwise adequately explained through detailed findings of fact, to reassess that part of the award. And as you say, perhaps she can buy him out. Perhaps he has an equitable lien on the sale proceeds if there is a sale for the amount due him, etc. But it seems to me it goes one step too far to reverse the determination to award her the home.
I understand the court's comments. I do think that there is not sufficient evidence on the record to just make findings that there is some kind of a discrepancy that can be justified through further explanation of the court, because what we're talking about here, as noted in Bradford citing Thomas, is that there to be an inequitable distribution, there would have to be an extraordinary finding or an extraordinary circumstance that the court could justify a disparate award like this. But obviously,
and that's part two. Right. of the remand I suggest. If that can't be explained, and you very well may be right that on this record it can't, then there needs to be a reassessment of the distribution, some opportunity to equalize that apparent disparity in a more detailed and thoughtful way than just, well, it'll all come out in the wash given the business, costs of sale, etc.
Yes, I think that's a very traditional approach by the Court of Appeals to send back for the court to make those kinds of findings and adjustments. And the focus of our appeal is that the court would send it back so that the assets can be analyzed and divided equally. We are asking the court to divide or to determine on remand what the actual values are. There is no evidence that the house is up for sale, so we believe that any sale cost would be speculative. We did appeal on two other narrow issues, one of them being the American Express card or account of $50,000 that was disclosed for the first time during examination at trial. We made a timely request for the court to have a new trial on that specific issue to allow discovery to determine what the source of those funds were. And then, yes, Judge Harris.
Yeah, on that issue, Mr. Christensen, I'm having some trouble following your position. If we're going to value all the accounts at the time of separation, we know what those values are. Then we know that there's a new account created in 2019 right before trial. Why does it matter what's in that new account that's created right before trial? If what we're dividing is as of the date of separation and we know what all that is, help me understand why that would matter.
Well, we don't know the answer to that question because we don't know what's in that account. If in fact all of that money, that $50,000 was accumulated after separation, then I think you're correct that we would essentially get back to the same place. But our appeal is not suggesting one way or another because we simply do not know. We were kept from being able to discover the source of those funds.
Well, I guess what I'm asking is, why does it matter what the source of those funds is? Let's say, for instance, that she had a bunch of money in an account as of the date of separation. You know what that account is. She took some of that money from that account and put it in that account, the $50,000 account. But you're entitled to half of what was in that first account at the time of separation. That's what you're entitled to. Whether she took that money and bought land with it or bought a car with it or whatever else, she's still got to pay you half of what was in existence at the time of separation. So I'm just having a hard time following the bouncing ball as to why it matters what she did with an account she opened several years after the date we're going to value everything.
What we don't know is where those funds came from. If they came from an account that was already divided, then you're correct. If they came from monies earned after, then you're correct as well. But what we're saying is we're entitled to know the source of those.
Where else could it have come from? It seems like it had to come either from an account you already knew about. There's been no indication that at the time of separation there was some other Grand Cayman account that nobody knew about. So it had to either come from accounts you knew about as of the date everything was being valued, or it came from her earnings after the date of separation. And in either case, it's already either A, accounted for, or B, you're not entitled to it. So that's why I'm having a hard time seeing how this issue matters.
Well, if you're right about that, the reason we're raising it is we just don't know. Maybe this is coming from a Grand Cayman account, which was never disclosed, because now we have on the record a non-disclosure, and we should have been entitled to disclosure of the source of that account. We may not know where that account was. It may not have been disclosed either, even though we asked for it in discovery. And that issue raises the last issue, which is Mr. Fischer. For some reason, the court is dividing his business account as of the date of trial, even though these are proceeds of his income. So similarly to what your honor is arguing, Judge Harris, the proceeds of that business should have been divided at the time of separation along with all of the other cash assets, and to divide that asset alone at the time of trial was an abuse of discretion and a double dip, is what we're arguing.
Well, but help me understand this too. I'm having a little trouble with this argument also. The court made findings that there was income given to your client every month out of the LLC, out of the business, right. But then some of it was booked not as income but as profit. And I think your argument is, well, it was all kind of the same. I mean, income, profit, it's all just money and it's all coming to him. But the part that's booked as income is the part that, that's his salary. The part that's booked as profit, the court made a different determination and said, well, that profit is profit being thrown off of a marital asset, and each party's entitled to half of that. And I guess I'm having a hard time seeing why that's wrong if the underlying finding is some of it's income and some of it's profit. Why shouldn't those things be handled differently?
Well, the 1099 income is the profit, and the W-2 income is the income you're referring to as salary. Both of them just are passed through to Mr. Fischer and reported as income on his tax return and paid for by him. Further, there's a double dip there because this profit is that's not an asset that's sitting in a bank. It's money that was passed through to him as his salary in two different forms. But what I'm arguing to the court is all of that happened after separation. This is his source of income. This is his salary. It should have been divided at the time of separation, and her salary should be divided at the time of separation as well. They should both be on equal footing.
All right, thank you, Mr. Christensen. You've got your 3 minutes still on rebuttal. Mr. Fitzgerald.
Yes, Andrew Fitzgerald on behalf of the appellee, Melissa Fischer.
Before you start, Mr. Fitzgerald, Mr. Christensen, would you please turn off your camera? Appreciate that. Thank you. Sorry, Mr. Fitzgerald, go ahead.
Thank you. The appellant is really asking this court to divide assets. I get one, you get the other. I get one, you get the other. And they're really trying to ignore the court's previous case law, where in Clark it says that the property distribution may not have been mathematically equal, is not sufficient grounds to constitute an abuse of discretion. So there's this idea that it's not always to be just a 50-50 cut. The court can look at, the district court is looking at the parties, they're looking at their demeanor.
Yeah, I don't think anybody's taking issue with that legal proposition, that a trial court can, in an appropriate case, make a unequal, albeit equitable, split of the assets. But the issue that I think Judge Orm was getting at, and I think I see here too, is that the court was purporting to do an even split. The court, in his oral findings, said, "Oh, this is supposed to come even. If my math is right, everything's even." The court didn't seem to be intending to do an unequal yet equitable split. It was intending to do an equal split, yet it came out this way without the findings that Clark talks about. I mean, if you're going to do an unequal but equitable split, you've got to make findings that support why you're doing that in this particular case. And because the court didn't appear to be purporting to do that, there are no findings to support, that kind of unusual outcome. So how do we make sense of this?
Yes, that's the hard part. The court made some efforts to show that reasoning, and perhaps the court could have gone further. It recognized how much value that Ms. Fischer put into the business and in developing it and supporting her husband, essentially financing him for years so he could develop this insurance business. And then it said, I can't really quantify her by monetary means, her contribution, but in light of that contribution and the fact that Mr. Fischer gets his business essentially free and clear, the division of how the house was divided is equitable. And certainly there could be more explanation to that, but I think that the explanation is sufficient to some extent, where we see where the court was going. The hard part about this case is that the appellant's numbers have changed about what he did and didn't get between the post-trial motions and in his appeal. And so what he's saying wasn't equitable and money-wise, the amounts of money has changed. It's changed at post-trial, and now it's changed in the appeal. Those numbers have shifted. What he doesn't mention is that his client got a $65,000 windfall in the quadro from my client. He doesn't mention that her hard work and savings gave him $65,000 in cash, or essentially a quadro to him.
What are you referring to as the windfall? I thought the retirement accounts were just divided equally. She may have had more in hers than he had in his. Is that what you're referring to as the windfall?
Yes. By the equitable split, he ended up with 65,000 of her.
65,000 more than she did.
Yes, she ended up paying him 65,000 to equalize the retirement.
But that was based on an order that accounts both be equally split, and the fact that her account had more in it than his did resulted in her paying him 65,000. But the retirement accounts were in fact equally split across the board, correct?
Yes, that's a correct characterization of it. So he doesn't mention that, and the retirement accounts were split based upon the decree, and my client continued to make contributions as she had prior to separation into that account, and Mr. Fischer stopped. So not everything's perfect, and I think Mr. Fischer is trying to create some sort of perfection in a 50-50 split that doesn't necessarily exist in the case law. The other thing about a remand for additional findings is that Mr. Fischer will likely appeal again. He's filed multiple motions that we've set out for the court that have been denied. He's been held in contempt twice post the trial on these orders. And there's a piece of this is that my client, she just wanted to be divorced. She just wanted to have her house. He could have all the other assets that the appellant's attorney says were massive amounts of assets. He got all of those, and those were all of his valuations. He had brought in 2 books, 2 giant binders of valuations that were all Mr. Fischer's, and we didn't object to any of them. All of that is his evidence, and he was given all of those items. She just wanted a car, and she wanted her house. Mr. Fischer had went out and bought a new house. He went out and bought a new car. He took out a lot of debt. At the trial, he tried to give her his post-separation debt. So my client wants to be done. She doesn't want to have this dragged out. There's one of the things that the district courts are able to do is they're able to see the parties. They're able to pick up on tone and the way people are in court and evaluate a person's demeanor and their truthfulness, and to decide what will be fair and what will be the best split for these people. And so that's what the judge was looking at. The appellant wants this court to look at it in isolation, outside of what the district court had, and make new evaluations. They've always wanted a new trial. They want a new trial on the evidence that they've presented already, that was undisputed, that was all theirs. And so there's that human piece where these divorces are ugly. There's hardship, and those are all things that the district court is looking at in making its analysis and deciding what is fair. And my client doesn't want to spend anymore. She's had to spend a lot of money on all these post-trial motions, and her belief is, and she's put this on the record previously, that when she was being divorced, that her husband said, I'll try to ruin you financially. And she feels like this process, this appeal after 2 failed motions, and Mr. Fischer being held in contempt twice, is part of that bad faith, using essentially the courts as a tool. And that's why she's asked for attorney's fees that we cited later in our brief. And so that's really what's going on in the background. And that's what the district court judge is picking up on. He hasn't really specifically written all that in, which maybe is the issue with the court, but those things are going on. Regarding the Amex account, the $50,000 post-separation, the judge found that the the appellant, Mr. Fischer, went and took out tons of debt. Ms. Fischer was conservative and she saved money, and approximately $27,000 of that particular account came from CDs that my client was awarded through her hard work, that they were her CDs. And at the time of the separation, Mr. Fischer stole them, essentially took them. And then he later gave them back. He split it half and half with her, and he gave them back, and she put it into that account. And then she saved her own money. And so really he's asking for monies that aren't his and shouldn't be his because she saved and he went out and spent.
Mr. Fitzgerald, when she identified that account during trial, was she asked by opposing counsel what the source of it was? What kind of questions were asked of her?
I think she was. So it was toward the end of the trial. She was being cross-examined. Mr. Christensen asked her about this account. She talked about the account. I can't remember for certain, but I'm pretty sure that she said that she indicated that some of the money came from the CDs that were in her name, and that the rest of it was just money that she had saved. And so I think then they could have further cross-examined. They could have asked at the time for the court to give them additional time to explore that further before making its decision. They did none of that. They made no objections. Mr. Christensen asked the questions and then he stopped.
So were the CDs she identified, were those marital assets at the time of the separation, or when exactly did those come into being?
She had those. They had those. So the other thing about Mr. Fischer is he was in charge of all the finances their entire marriage. So he knows everything about what they had. And he knew that she had some CDs that were given to her as part of her career as a skilled nurse from one of the companies she'd worked for. At the separation, he took them out of their safety deposit box or wherever they were kept and took them for himself. We made an issue out of it and said, look, those aren't his, they're in her name. And he essentially cashed them and then gave half of it back to her, of which she put into the American Express account. And my understanding is that Mr. Fischer knew about this. He knew that at trial cross-examination that was part of that money. He went out and spent plenty of money, went into debt, and then tried to dump it on her post-separation in the trial, which was more bad faith, I thought, on his part. And it's really not the argument that Mr. Fischer doesn't know where these are from, that's from the Caymans or a Cartagena bank account. He was in charge of all the finances. He knew what they made. They did it together. He was in charge of all the finances. And so that argument that we just don't know where it came from and it must be some secret is just not tenable. And I don't think they preserved that properly. And by the way, in their first motion, as we put in our brief, they didn't even bring that up. It was only their post decree that they brought that up. So they had 6 months while they essentially ignored the court's order for them to draft the divorce decree. And it gave them 6 months to come up with another argument that they didn't bring up in their initial motion. Really, the appellant wants a new trial. He wants to retry everything. We think part of it's harassment and is not in good faith. And that my client should be awarded her attorney's fees for all the difficulties she's been given. And the court said in our contempt hearings that regarding Mr. Fischer, that he can't give an honest answer to an honest question, and that is all in the lower court record post trial. And so that is a dynamic that's going on. My client just wants to be free and live her life. She wasn't terribly obsessed with assets and money. She just wanted to have a new life. She was a child bride and needed to get out of something that was very unhealthy for her. And she just wanted some basics. And Mr. Fischer just keeps asking for more and more, despite him receiving an entire business that is valuable. Everyone here in this courtroom knows that a book of insurance can be sold. Insurance companies are sold all the time. They're very valuable. He walked out of the courtroom with that entire book of insurance, and she didn't get any value of that. And
So-
as we put in our briefs, we think that.
So
Sorry, Judge, go ahead.
why not make an effort at trial to prove that that business has an ongoing value that could be sold to a third-party purchaser? I mean, there was no effort by either party to indicate to go out and hire somebody to value that business. And I know that costs money, and that's probably the answer. But it seems like if you think this business has, significant value, it's worth paying a evaluator a few $1,000s to do a valuation. And I guess I wonder why neither party thought that was worth doing at trial. And could you shed any light on that?
Yes, the answer to that is Ms. Fischer is very reasonable, and she felt like that's his business. I just want to be divorced. I don't want to spend $10,000 having it evaluated. She makes income, he makes income. She really just wanted to be done, and so that really wasn't her priority. Now, after Mr. Fischer has dragged her through multiple motions, been held in contempt multiple times, and he's saying, well, I want to see this bank account post-separation. And we're saying, okay, well, let's see your business bank accounts post-separation if you want to be equal. But that really doesn't work because the trial's done. You don't get 3 and 4 shots at having a trial simply because you don't like the way it came out. And so Ms. Fischer is saying, well, look, if you really want to go and reevaluate the property and all these things, we'll pay $10,000 for a business evaluation. And at a low end, it's probably worth $500,000 to Ms. Fischer. That was never her intent in the start. She just wanted to have a split, do it amicably and in good faith. And unfortunately, she's had to fight this very difficult situation, having to spend money on more money than in the actual divorce. And so she would ask that this court affirm and let her move on and let this relationship close, and so she can finally heal.
Thank you, Mr. Fitzgerald. We appreciate your argument. Mr. Christensen, I believe you've got 3 minutes, if I'm not mistaken.
Thank you, Your Honor. First, I want to note that the issues of the business valuation have not been appealed. There's no cross appeal here. The court has made specific findings as to the business, and those should not be remanded for further determination. They have not been challenged. The business is not a book of business. The court found specifically that Mr. Fischer had one client, and that is the credit union trust, essentially. It's not something that you can go out and sell. The court found that he just is paid money from that client. He deposits it in his LLC, and then he takes it out as income. So the business is without value. It's more tantamount to a sole proprietorship. In terms of what a lot of information has been put before the court of things that are not on the record and not argued in the briefs. That doesn't change the ultimate fact here that the court went through and intended to make an equal division of the assets. And but for awarding the house to Ms. Fischer, the court easily could have done that, and frankly could have made up for the value of the house through the retirement and cash assets in a different way as well. But we're asking the court to remand, ask the court to determine a fair, equal division of the overall divorce assets, and consider the ability of the court to have the house sold, divided between the parties, or bought out from one party to the other. It is the major illiquid asset of the parties, and the court has several options of how to make that equal division work. In terms of the smaller issues, we're arguing that the American Express count was not disclosed. It was a surprise. It happened after separation, and we did not know the source until cross-examination. That should be disclosed. We asked financial discovery. There were initial disclosures. There was an updated financial declaration filed within weeks, like 3 or 4 weeks before trial. And it did not have any mention whatsoever of an American Express account. And on the final issue, Mr. Fisher's profits from his business are just his income, and it was money that was earned after separation. The court should apply the same valuation date for him as it did for Ms. Fisher. Thank you, Your Honors.
All right. Thank you, Mr. Christensen. Mr. Fitzgerald, if you want to just turn your camera on for a quick moment. We just want to thank you both for your arguments today and your briefing. We will take this matter under advisement and issue a decision as soon as we're able to.
Thank you.
This court is now adjourned.